Hello and welcome to another episode of Talking Politics here at The Hindu with me, Nistula Hebbar, where we unpack the news making the headlines in domestic politics. Last week saw many events unfolding in domestic politics which will have implications for the future. These include the goings-on in the Maharashtra Vikas Aghadi government in Maharashtra, with Congress MLAs from Maharashtra trekking to Delhi to complain about being neglected by ministers of their own party in the government. The intercession of Nationalist Congress Party Chief Sharad Pawar with Prime Minister Narendra Modi over raids by investigative agencies of the centre on Sanjay Raut, Shiv Sena leader and MP, and an attack by alleged workers of the MSRTC on Mr. Pawar's residence, indicating some issues that could affect political events and developments at a later stage. All this happened during the second part of the budget session of Parliament, held in the background of the 4-1 victory of the BJP in the last set of assembly polls in 5 states. The opposition managed to adjourn the two houses of Parliament multiple times over price rise, but the lack of a united opposition meet being held, even under the leadership of the Congress, as well as the fact that the party lost a seat in the Rajya Sabha polls in Assam that was undertaken in that period. This was a seat that they should have won, dampened the proceedings for the opposition, and the morale seemed to be a little down. This brings us to the subject of this week's Talking Politics. It's not going to be any of these things, though the goings-on in the MVA and what actually happened in the Assam Rajya Sabha polls is extremely interesting. But this week, we will be talking about the passage of the Criminal Procedure Identification Bill 2022 in both houses of Parliament. This has raised many apprehensions over its effect on the right to privacy and the right of individuals not to incriminate themselves. What is this bill and what are the justifications behind its passing and the apprehensions with regard to this? That will be the subject of this week's Talking Politics. Last week, in the second part of the budget session of Parliament, the Criminal Procedure Identification Bill 2022 got cleared in both houses. This bill seeks to replace the Identification of Prisoners Act of 1920, which was passed under the colonial government of the British. And this new bill was passed by voice vote after debate, and the response was provided by Union Home Minister in a very detailed manner in both houses of Parliament. What are the provisions of this bill, which has raised hackles across the board? Well, the bill provides for legal sanction to take appropriate body measurements of persons who are required to give such measurements for the efficient and expeditious conduct of investigations. Basically, it has expanded the ambit of the measurements to be taken by law enforcement agencies for the identification of people involved in a criminal case. This includes not just the old measurements of footprint, palm print and fingerprints, but they also include iris and retina scans and physical and biological samples and their analysis. It seeks to empower the National Crime Records Bureau of India to collect, store and preserve the record of measurements, and for sharing, dissemination, destruction and disposal of these records for a period of 75 years. In plain English, this means that the NCRB will be the repository of this data, which they can keep up to 75 years and which can be shared with other law enforcement agencies across the country. So therefore, in this case, in the case of this bill, both the kind of measurements to be taken by the police and whose measurements are to be taken is being redefined. As I said earlier, measurements could include fingerprints, palm prints and footprints, photographs, iris and retina scan, and the little undefined bits of physical and biological samples and their analysis. It empowers magistrates to direct any person to give measurements and empowers, and this is, please carefully listen to this, it empowers the police or prison officers to take the measurements of any person who resists or refuses to give these measurements. And this basically, this new criminal procedure bill not only is for convicts. It not only does it take into account convicts, but also the accused and anyone held under any preventive detention law. That is, if you've been taken under preventive detention while participating in a political protest, the government was well within its rights to take all these measurements, all these identity markers, biological samples, and store it with them for 75 years. There is a provision for sharing the data collected with other law enforcement agencies, and nothing has been said of erasing the record of acquitted people. While the Home Minister Amit Shah, while piloting the bill, said that, and I quote, its sole objective was to improve conviction rates in the country, to protect human rights, and here he talked about the human rights of victims of crime. And he also said this was to send a strong message in society, and has not been brought in for any misuse. Opposition parties have termed the bill as draconian and against human rights. These were long debates that went on in both houses of parliament. Mr. Shah argued that the advancement of technology had meant that it was now possible to keep the police ahead of criminals, because criminals have themselves been seen to be using cutting edge technology to commit crimes, and the police cannot afford to be left behind in the technological stakes. And he said that the next generation crimes cannot be tackled with old techniques. He repeated his assurance that human rights will be kept in mind while framing the rules for the bill, which haven't been framed as yet. Well, the opposition on its part participated in the discussion quite enthusiastically, and they raised several important points with regard to how the bill could be misused by the state in crushing the liberty of individual citizens. For example, the phrase biological samples has not been clearly defined and could involve invasive procedures such as blood and hair sample collection and DNA samples, which currently require written sanction from a magistrate. Congress MP Manish Tiwari, also a lawyer, has flagged certain concerns. He said that the definitions of these measurements are ambiguous and nebulous. And I quote him, "I would like the Home Minister to clarify what he means by brain mapping and narco analysis. The bill, violates the personal rights given to an individual when a magistrate can direct any individual to furnish details even if they choose not to part with it." He also flagged the fact that civil society stakeholders had not been taken on board while framing this bill, and he also looked at some of the ambiguous language that has been used in the bill. He says the legislative intent of the bill is not clear when the government writes that people who have not been booked for crimes, who have been booked for crimes which carry punishment of less than 7 years may not be obliged to provide their measurements. That word may should have been shall. It would have had a stronger impact, because the word may is ambiguous and therefore also makes a legislative intent ambiguous. It is being apprehended by opposition leaders that even Article 20 bracket 3 is violated under this bill, that of the right against self-recrimination. Well, all of this happened. This bill was not sent for parliamentary scrutiny, and rights activists across the country are now mulling about what can be done to provide a challenge to this bill, because once the President of India signs it, which he is likely to do in the coming week, it will become the law of the land. So one suggestion which is being given is to have a robust data protection law. There is the new data protection law has been hanging fire for the last 5 years. It is still with the parliamentary committee, and rights activists say that if there are stringent punishments for violating the right to privacy of any individual under this law, it will act as an effective counterweight to any kind of police excess in collecting measurements, etc. There's also talk of a judicial challenging the bill or the act in court to argue for right to privacy and individual liberty. All of that, of course, is in the future. There is no doubt that a new age crime cannot be fought by old technology. That is a very, very legitimate concern in an age where technology is getting ahead of us every day. But old concerns on the rights of citizens, very hard fought through the freedom movement and post that, and the role of the state needs to be balanced. That is my little editorial point on this episode of Talking Politics. That's all I have for you this week. Thank you very much for watching.